Good morning. Are you Alexandria Bledsoe? And this is 25 DCCR 0004. Ms. Bledsoe was previously in court and entered a plea of guilty to the state jail felony offense of abandoning or endangering a child with intent to return. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor. Yes, sir.
Any additions or corrections?
Only one minor thing my client would bring up. The name of her employer was Cigna, right? Or Sigma? Cigna. It was listed as Sigma, and she was just worried that that might be an issue. I told her not to worry about it, but she wanted to bring it to the court's attention.
Okay, thank you very much. Anything else?
No, Your Honor.
All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include completing an intensive parenting class. If you haven't already done that through CPS, there's going to be something through probation that you're going to need to do, obviously. If you do everything that you're supposed to on this probation and follow all of the rules and conditions, then this is an excellent opportunity because you do not have a felony conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could go to the state jail prison for up to 2 years. Do you understand? Okay. Obviously, I would like to think that this was a huge wake-up call because this could have been very, very bad. And so take care of your child, take care of the classes, make sure you make all of the right decisions when it comes to that, and you shouldn't have any issue. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. Thank you, Mr. Rennick. And Mr. Rennick, you also have Patrick Gallagher sentencing, 24 DCCR 2422 sentencing. Good morning, sir. You're Patrick Gallagher. And Mr. Gallagher was previously in court, entered a plea of guilty to driving while intoxicated, third or more. And I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Your Honor, yeah.
Are there any additions or corrections?
Nothing was mentioned.
I didn't see any, Your Honor.
So, Mr. Gallagher, you want to know what my big concern is? How long were you off probation for your DWI second when you got your DWI third?
I can't remember.
4 days.
4 days.
Mm-hmm. That's what it looks like to me. It expired, community supervision expired, looks like October 3rd of 2024 is the way this reads. New case, October 7th of 2024. What, if anything, have you done with regard to any kind of drug treatment? Anything on your own to stop using alcohol or drugs?
I quit drinking and I pray to the good Lord because I'm a single dad with grandkids, so that's over with.
Well, it should have been over with when you were on probation last time.
Yes, ma'am, I agree.
And I appreciate that you're praying, but sometimes that's not enough.
I agree with that too.
Are you still working
Yes, ma'am.
at Exxon?
Yes, ma'am.
Judge, there is one issue I need to bring up whenever you're done speaking.
Go ahead.
I'd spoken to the prosecutor about this. He is a full-time shift worker, and one of the issues was he had brought in his work schedule as if the court was willing to, he had dates that he was not working to do the 10 days.
Okay.
And that is something I want to bring to court's attention.
Sure.
Oh. You weren't quick enough. You were quick, though. Okay.
It was the highlighted dates is when he is not working that he was asking the court to. I know he knows it's a big ask, but.
Well, I mean, I don't know. It kind of is. It kind of isn't. Typically, I let people who are working do it on weekends. This is just how the weekends
I have no
for his
issue
weekends.
with the erratic dates, Your Honor.
Here's the more, I guess, the part that's going to be potentially something that you're going to have to really figure out with your job schedule, and there's not going to be any excuses, is that you're going to have to enter and successfully complete the JCDI program. It is an intensive outpatient program. You're not the only patient that will have to do it on this type of schedule, but you're going to get started on that immediately without any mess ups, because if so, you're right back in here and you're going to be looking at going to prison. Do you understand? So what I'm going to do then, Mr. Gallagher, is find that you entered your plea of guilty freely and voluntarily. Have you been wearing a drug patch either, or no? Was that a condition of anything? I didn't,
No, Judge. it
the
wasn't.
bond, it wasn't a condition? Well, because there was, the blood came back with positive Delta 8 THC. I'm sorry?
That's correct.
Yeah. Are you doing anything like that still?
No, ma'am, I work for ExxonMobil.
Well, I mean, did you work for them when you,
I did, but I had a vape that I didn't know was there, so that's history.
you're 52 years old and you're using a vape that you don't know what's in it? You want me to buy that?
You don't have to, don't have.
I don't. Because if you don't know, then you should have known. So either way, it's ridiculous that, I mean, that's something that a teenager would come in and tell me, I got a vape and I don't know what's in it. All right, I'm going to do this. Going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow your agreement. Find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement. Well, actually, I'm not going to follow the agreement with regard to the length of time on probation. The fact that he was just off of probation, I think, warrants longer than a 5-year probation. The length of your probation period is ultimately up to me anyway, so it's not like I'm following the main part of the deal, but you still wouldn't have a right to appeal because that's up to me. So I'm going to find you guilty, sentence you to 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that and place you on probation for 7 years. You're ordered to follow all of the rules and conditions of probation. That's going to include entering and successfully completing the JCDI program and following, obviously, all of the rules and conditions. You'll have an auto ignition interlock device on your vehicle. Do you already have that? You're going to keep that at least for some amount of time. And if he has the interlock, you can make a notation. I don't need interlock and scram and portable, whatever they feel like is best through JCDI. Once that gets going, I'm fine with. I am going to order that you serve the 10 days upfront time. That is going to be on the date starting, I'm going to attach, I'll give you this copy as well, but so like where it says 9 nights, you work that night
Yes, ma'am.
of the 9th.
It's like all night
So-
I have to.
So you'll start on October 10th. I want you to turn yourself in October 10th at 6 p.m. And then you'll spend the 10th and the 11th, and they'll release you on the 12th. Okay?
Yes, ma'am.
And then when you work days, what time do you get off?
4 o'clock.
4 o'clock p.m.?
Well, it depends on when I leave, so it could be 4 to 4:30 to 5.
Okay, so the next time is going to be, since you're working days on the 16th, you're going to go at 6 p.m. on the 16th, and then you'll spend that night, the 17th, and get out on the 19th. If you don't have something written, days or nights, does that mean you're off?
And we're so short-handed, it's a possibility, or I had to work overtime because I gave up 2 days overtime already for the 11th and 17th.
Okay, if it doesn't say days or nights on this calendar, does it mean you're off?
Yes, ma'am.
Okay, so that second one in October, you're gonna go, we're gonna get this done. Because that's your long days off. So we're gonna get that week done. So you're gonna go in on the 16th, and you're gonna get out on the 23rd. So that gives you one overnight, 16th, 17th, 18th. That gives you 7 days. And then that first one only gives you 2 days, so that's 9.
So you're saying go in on the 16th when I get off work that day? Mm-hmm. Okay.
And we're just missing 1 day.
There's 7 November on the back of it there.
No, we're getting this will be done in December, so you're gonna then go in on the 28th
Yes, ma'am.
at 6 p.m. and you'll get out the next day, and I'll take care of that last day. So, and then Anna will probably need that too. Make sure you get all of those done. Okay. All right. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rennick. You need to have a seat here in the courtroom and wait for probation to call you up. She'll call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Yeah. What was it? Uh-huh. Okay. All right, you're David Holland? Okay, so a couple things. First of all, this was the final reset with regard to what was going to take place on your case here. So what is the announcement?
Judge, we haven't, the money hasn't come in yet. What I asked Mr. Coleman a moment ago was that while he was in custody, if he should get the money in to pay it, I don't know how that would get conferred to me or to the court or anybody.
Where's the money supposed to be coming from, Mr. Holland?
I have it. It's on. I have it. I have most of the money. It's on my friend's card. I tried to get on last night and this morning, but he didn't answer me or nothing. And I didn't have time to go out to his house. So he lives in Bevel Oaks, and I was like,
It's on his card?
he has money in his bank. He's going to send it to me on my Cash App card. And that way I'd have it. But
Okay,
get
so,
home last night and get
so
home
here's,
this morning. I didn't wanna drive out there.
well, I'm not gonna reset it. Y'all need to take care of this in another way. It can be some type of probation where he pays it back.
I made an alternative recommendation.
Y'all need to get that paperwork done, or it's gonna go on the trial docket. We're not waiting anymore.
This is a different version than what the defendant gave you the last time.
It is.
The source of the.
No, we're gonna it's gonna get taken care of today. Y'all can get the paperwork done. Obviously, if there's money that gets paid early, then sometimes probations are terminated early, but the case is 1,600 days old, so.
The state's alternative offers 2 years, the minimum of 2 years, given the defendant's criminal history. He's had a aggravated robbery probation that was revoked to looks like to 10 years, and a number of, a third degree evading. In 2003, they did 7 years on, and the POCS, looks like we did a concurrent two years on that, Judge. Maybe some history out of the state of Ohio. I'm not inclined to offer probation, Judge.
Oh, okay. But if he had all the money, it was gonna be,
A misdemeanor, Judge, and just a little time in misdemeanor in county jail.
and we've got this warrant now, because you didn't go take care of that either this last week.
Because I worked all week and you guys not paying me till Wednesday, so I mean, there's nothing I could do. I didn't have any more money to give. I mean, I gave it all to my friend, so he'd hold it for me so I wouldn't spend it. Because I hadn't got the money from the
Okay, so here's the thing.
court yet, bankruptcy.
Okay. It's, obviously, you know what the offer is. Y'all can take that offer, you can reject that offer and go to trial, but something's going to happen today.
I'm sorry, I can't hear as well as I used to.
So the offer is, I'm not going to reset it again
I understand.
for the restitution. So it's either plea to whatever the offer is, plea open to the court, or do a plea bargain rejection, and I'll set it for trial. So have a seat over in the jury box, and y'all take care of whatever paperwork it is. I'll need paperwork for any of those.
Yes, ma'am.
Good morning, you're Presley Viltz. And Mr. Viltz, did you get someone hired? Who'd you talk to?
Scott, King,
Speak up, please.
Scott, and
I can't hear a word you're saying.
Kimberly, James.
James who? Okay. So where are you on being able to get one of them hired?
I just started taking back on the work.
Okay, where do you work? Say?
Court.
Okay, so what I'm gonna do, thank you for visiting with those attorneys. I'm gonna give you one more reset, see if you can get some funds together to hire one of them or anyone else. If you get them hired, bring that reset notice. If it's not gonna work out with one of them, talk to 3 others, bring me those names, and we'll discuss your options if you're still unable to hire someone, okay? So make sure you talk to 3 others if you don't get somebody hired. All right, step in front of the clerk. Good morning, are you Richard Robb? And Mr. Kimler, will your client waive the formal reading of the indictment?
Judge, with the court's permission, we will proceed on the lesser included Class A theft. We've determined that there is no restitution.
All right, thanks.
And I've altered the judicial profession to reflect that,
Thank you. All right, Mr. Robb, in cause number 24, DCCR 2170, the state has elected to proceed on the lesser included offense of a Class A misdemeanor theft from September 1st of 2024, and how do you plead to that charge?
Not guilty.
Guilty.
Guilty or not guilty?
I'm sorry, I missed that. I didn't hear that.
Guilty.
The theft part.
So lesser included
It's
misdemeanor.
lesser included. I can't have that. I didn't hear it.
This is
Okay,
confirmed.
I'll hold it. Y'all go visit and make sure he knows what's going on before I go any further. Then with it, please, ma'am. Good morning, Mr. Cole.
Morning, y'all.
Good. Good morning, sir. Are you Leonard Heidelberg?
Yes.
This is cause number 16 25968. It's the MTRP. I feel like we're waiting on, there was a motion for a competency evaluation,
Yes, ma'am. I e-filed the
but I don't see that it's been done yet.
it's been done.
It has, we just
Yes.
don't have a report yet.
It should have been e-filed into the case, Your Honor.
The report?
Yes, Your
They
Honor.
sent it to you?
Yes, Your Honor.
Not
Oh.
to me, not to you.
Oh,
I mean,
okay.
I certainly take
Who
Mr.
did it?
Cole's word for it, but
Dr. Riggins out of Houston.
Oh,
The court wouldn't pay for his evaluation.
I don't see that it's in here yet.
I do have a copy of it.
Can I see it real quick?
I'll have to send it to your email, Your Honor.
Oh, okay.
Yes.
All this paperless stuff.
Yes, Your Honor.
Finding competent, not competent?
Not competent.
Okay.
not competent or
Dementia.
dementia?
Dementia.
Because I think there's a legal difference.
Yes.
Yes.
Yes, it was dementia.
Okay. We need to take a look at that. I'm going to reset it 2 weeks.
That sounds great.
If you will make sure, it should, if you e-filed it, it should be coming through, but if you'll also just in an email forward that report to Ms. Malfino and I,
Yes.
and that way you guys can take a look at it, talk and see if there's something that you can work out. I can look at what my options are with regard to that diagnosis, and then we'll see where we are in 2 weeks.
Judge, just so the court is aware, I spoke at length with his probation officer, Ms. Hunter, last week. Previously, when we were here, I believe back in June, you ordered that he not drive, and you spoke with his wife here at
Yes,
court.
yeah.
Ms. Hunter relays that he is complying with all that. She
Okay.
actually comes to his appointments
Good.
with him, and that everything seems to be
Okay.
going well with respect to that condition.
Okay, well, maybe we'll be able to work it out with just modified type probation. We'll see. Okay, all right, we'll see you in a couple of weeks. All right, good morning, sir. You're Stephen Hayes. And Mr. Hayes's cases are set for trial to begin with jury selection next Monday. And what is the announcement?
State your, ready?
All right, any negotiations or anything we need to talk about that anything's changed? It will very likely be the number 1 case due to the nature of the offense and the age. And so if anything changes with any negotiations, really need to know by tomorrow when I set that trial docket tomorrow after docket. Stay in touch with Mr. Jeffries, and so that we know if anything changes, we'll get that taken care of this week. If not, we'll see y'all next Monday.
Yes, sure.
All right,
Thank
free to
you.
go. Thank you. All right, sir. Are you Lawrence Jackson? Are you sick right now, Mr. Jackson?
No, ma'am, I just said that.
Yeah, pull it down so I can hear you better for now. Thank you. And Mr. Jackson was previously in court in cause numbers 24 DCCR 1669 and 25 DCCR 0189. Entered pleas of guilty on each of those cases of driving while intoxicated, third or more. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
No, Your Honor.
Not from the state.
I guess this is just somewhat lucky because one happened before the other one was. All right, Mr. Jackson, I'm going to follow the agreement that you made with the district attorney. I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. I'm going to find sufficient evidence in each case to find you guilty. In cause number 24 DCCR 1669, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation, which includes entering and successfully completing the safety program. In cause number 25, DCCR 0189, also find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. Sentence you in accordance with that agreement to a term of 10 years in prison, but suspend that, place you on probation for 10 years. You're also ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation, including entering and successfully completing the safety program. If you do everything that you're supposed to on these probations and you're successful, then for all practical purposes, your case here in court is over. You'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation at all, you can be brought back into court and you can be facing that 10-year sentence that you've already agreed to. Do you understand? I only have one of, I don't know if y'all can get to it. I need the certification in 1669. I'm going to hand you the trial court certifications in each case that shows that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It's okay. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir, and we'll get that other copy in a little bit. That's just pro fill out one. We'll get it. He has the one. Can you make a note? I started noticing on this one. She's. Good morning. You're Hillary Lawrence. And will your client waive the formal reading of the indictment?
No, Your Honor.
Ms. Lawrence, in cause number 25, DCCR 0296, you're charged with the state jail felony offense of theft of service, and that's from February 6th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? Bless you. And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would not be a fine, but there would be restitution, and that would be determined before sentencing. Is that correct? Y'all don't know the amount?
Yes, that's correct, Your Honor.
Okay. Is that your understanding of the agreement? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Lawrence is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Also, that'll give them time to figure out that restitution amount. When you're leaving the courtroom today, you need to stop and talk to probation, and she's at that desk right over there, okay? All right, we'll see you back at sentencing. Then you've got Mark Hebert. This is sentencing, Mr. Parker. Good morning. How do you say your last name?
Hi.
Paye. I feel like we've done that before. Mr. Paye, sorry. Did you get someone hired?
I'm still in contact with Mr. Jeff Casey,
Uh-huh.
and I still want to get him hired, so I got a second job. In order to do that, you asked me to bring the check stub.
Okay. And where's he from?
I'm not 100% sure, but he's with Jeremy and Jones, that law firm.
Okay.
This is my check stub from FedEx, and I started my new job this week.
Okay. You get paid every week or every 2 weeks?
Every week.
Okay.
But the hours vary from about 20 to 30.
And where's your new job?
It's in the law and out there.
Okay.
Pivot.
Okay. So I'll give you a little more time. I mean, you're trying and that's great, or I can have you fill out some paperwork to see if you qualify. You want to try that today? Okay. Step in front of the clerk and she'll give you that paperwork. Make sure you fill it out accurately and completely, okay? Good morning. Are you Romeo Johnson?
Yes, ma'am.
And this is cause numbers 24 DCCR 2095 and 2419. Mr. Johnson's cases are set for trial to begin with jury selection next Monday. What is the announcement?
We're ready, Your Honor.
All right. Anything that changed in negotiations that we need to go over today?
I was given some additional discovery materials, but it's just a complete autopsy.
Okay.
There's no new offer or anything for me to present to my client.
I'll entertain a counteroffer.
All right. If y'all want to visit this morning, just to double check if there's any counteroffer or anything like that, let me know. I'll hold it for a minute. Otherwise, it'll get numbered for trial.
Yes, Your Honor.
Okay. Thanks. All right, you're Kaylin Salzar. And Ms. Salzar is on probation in cause number 24, DCCR 2234. And that is for a misdemeanor offense or a case that was reduced to a misdemeanor. It's an unadjudicated probation. She was placed on that probation April 21st of this year. And it was a criminal mischief that was reduced to an attempted criminal mischief. A motion to revoke has been filed, or motion to revoke unadjudicated probation. It alleges a DWI from August 23rd of 2025. It alleges a failure to report in August, failure to perform community service, behind in court assessed fees, that she admitted to using alcohol in violation of her probation August 23rd of 2025. That she has not completed a cognitive thinking class as ordered. And in addition, we have a pending felony case of assault on a peace officer with an offense date prior to her getting the probation in this case. And so that's not alleged, and it's standing, I guess, on its own at this point. Mr. Kimler has filed a motion asking that I set a bond in the misdemeanor probation case where she's on an unadjudicated probation. Mr. Nichols, what's the state's position on that?
Your Honor, in addition to the two cases before you, she has two separate DWIs that are pending lab results that have not yet been filed. One is from March and predates this probation. One is from is what's listed in the motion. It looks like the only thing holding her is the bond on this case, and if she's in light of those arrests and what's alleged in the motion, if she's going to be granted a bond, I ask there be an interlock. And I would suggest she not be allowed to operate a motor vehicle, period, instead of an interlock. If she does have the interlock, I don't think she needs to be at all. But she wants to go into rehab, Your Honor, and that's really the purpose of me trying to get her a bond. bond? Where have you talked about?
Well, and here's the thing, you don't get to pick all of that. She's on probation, so that has to go through probation. In addition, we have another case pending that, depending on the length of everything, I'm not just gonna put off. And so obviously, if there needs to be some rehab, then I'm all for that under the right circumstances. But if you make a bond, you can't just go off somewhere without
Right.
it being approved by probation and ultimately by me, so that we know what that is, where it is, and what that means with regard to that assault on a peace officer case.
It was just, that's her intent. She does recognize that she has an alcohol problem. I've talked to her extensively about that.
Hold on a second. So, Mr. Nichols, any other input?
If it's not gonna be, and I agree that maybe her not driving at all is probably the best course, but there needs to be some sort of monitoring, like a scram or something along those lines, right?
I agree. So what I'm going to do, Ms. Salzar, in cause number 24, DCCR 2234, is to grant that request for me to set a bond. I'm going to set the bond at $10,000. Condition of that bond is you are not allowed to drive anything, no vehicle, period, ever. You will be required to wear a scram device. Obviously, if that tests positive for alcohol, then you will be in violation of your bond conditions. That bond's going to get raised, and you'll be able to wait all this out while you're in jail while it gets sorted out. Do you understand? Any other conditions that?
I think that should cover it, Your Honor.
Okay, and so what I'll do then is we'll reset, a normal reset, and see what we need to do on this, obviously, as well as the other pending felony.
And then she needs to report to her probation officer as soon as you make bond.
Yeah, you're still on probation, so go straight to your probation officer, talk to them about what you need or can do, and then go from there. Okay.
Stay in touch with your bonds.
I contacted him and he was sitting in the Beaumont Municipal Court waiting for his name to be called. So
Oh,
I
wrong.
apologize for that.
Yep, a lot more serious than that over there today. Mr. Hoffpower, this is yours. I'll recall the bond forfeiture. And this is cause number 24, DCCR 1998. Mr. Turner's charged with criminal mischief, and what is the announcement?
Judge, we're just asking for more time to review evidence. We haven't had a chance to do that yet.
Okay, and any issues?
No, Your Honor.
All right, so I'll just do a normal reset. Make sure you stay in touch with Mr. Galmore so you can go visit with him before that next court date and see if we can get an announcement. All right,
Thank you, Judge.
thank you.